Morning, everybody. Thanks for being here. We're going to keep fighting for student athletes in Tennessee. I think the hearing was very educational. The court is clearly grappling with these issues, and the big issue is our student athletes getting an opportunity to find out what the actual value of their NIL rights is. And one of the things most interesting that we heard is that even the NCAA is a little unclear on the NIL rules. At one point we heard that the student athletes are able to talk about NIL opportunities. Then we immediately heard, well, actually they can't really talk about them with anybody who's actually going to make the decision. The lack of clarity is hurting student athletes. The lack of opportunity to make informed decisions is hurting student athletes. It's not right and it's not legal. Federal antitrust law guarantees them the benefit of a free market, and we're going to keep fighting to ensure that that's what they get.
We'll take a few questions.
What type of irreparable harm do you think that UT football, UT the university is suffering beyond the monetary value of its athletes?
I mean, we could talk about the university for sure. It's a huge contributor to the economy. UT Knoxville in East Tennessee is bringing hundreds of millions of dollars in as a result of college athletics. But this case is really about the student athletes. That's whose rights we're fighting for here. And their irreparable harm is not being able to make an informed decision, not being able to get the benefit of negotiation. And when everybody else is getting rich off college sports, and the people who are responsible for creating college sports are the only ones who aren't allowed to prosper, that's a problem, and it's not legal.
You referenced the kind of talking in circles in there. You can have a conversation, but you really can't have a conversation. When Judge Corker kind of countered back with, isn't it against your rules that boosters are allowed, or collectors in this instance allowed to have? Did you think that was kind of a turning point in the hearing?
Well, I never want to read too much into any one comment because there are a lot of factors at play. We've got a thoughtful judge who's going to look at all the arguments in the record. But I think it's important for the public to understand that these kids are subject to potentially severe penalties for rules that have been changing over the last few years and that still today in a federal courtroom aren't totally clear. And it's not right to subject people to serious punishment when they don't know what rules they're supposed to be following. So I did think that was an important point that came up.
About Tennessee's law, the NCAA made a point that they think the relief you all are seeking is against Tennessee's law. Can you explain why that's not true?
Yeah, so Tennessee's law says you can't pay somebody for attending the university, but obviously if you're paying them for their NIL rights, one of the factors is where they play. If somebody's playing football at Harding University, their NIL opportunities are probably a lot different than their NIL opportunities at, say, the University of Tennessee. And that's just a result of the market and the fan following. So where you go to school is going to factor into your NIL value. But you can't pay someone just to go to school. That's pay for play. And it's a weird distinction for sure. But that's where the law is. You can pay someone for their NIL rights. Those are intellectual property rights that they have. You can't just flat out pay them to go to school.
Do you feel pretty confident moving forward with this?
I think in the long run, we have a very, very strong case. I don't want to make predictions about the preliminary injunction. I think we put on a great case in there. We had a great argument. You never know which way it's going to go, but in the TRO order, the judge said that we are likely to prevail on the merits. I continue to think that that's right. The law is what the law is, and we have very strong arguments on behalf of Tennessee student athletes.
For people that are ignorant about a lot of this, do you think it's important to note that, as you said, in the long run, you got to think big picture. This is a small battle than the bigger picture.
Yeah, whatever happens today is not going to tell us what's going to happen in the long run. This is about immediate relief and whether the NCAA can continue to threaten enforcement of these rules in the short term. In the long run, we're fighting about whether these rules are legal at all, and that's the most important part of it. That's the big fight.
Is there some sort of agreement that you would, or not agreement, but the judge would come back with some truncated version of an injunction? Is that something you would be fine with, or I know you take the judge either way, but what would you prefer, I guess?
I mean, I think there are a few different ways the judge could approach this, and he was asking questions and suggested he's looking at all his options. Our goal is to protect student athletes, and if there's some sort of intermediate relief that accomplishes that goal, I'll be very happy with it. Either way, no matter what happens with the preliminary injunction, we're going to keep fighting.
Can you see why an athlete maybe a recruit would have a difficult time distinguishing between what they can or cannot do in NIL?
Yeah, it's difficult for attorneys to figure out what they can or cannot do with NIL, and we've had 4 years of college and 3 years of law school. If you're a high school kid trying to figure this out, you're going to have an extremely difficult time, and that's a big problem because the consequences are so severe, the rules are so complicated and so nebulous. It's not right to subject these kids to this, this unknowable situation where they're putting their necks out there and they don't know whether they're going to get in trouble. They're making these big decisions that are going to have serious financial and educational implications for the rest of their lives. It is not the environment to have complicated, obscure rules.
It's your understanding that regardless of whatever the injunction is, if you were to grant it, it would be nationwide. It seems like both the NCAA and the state of Tennessee has agreed that would be the appropriate action.
That's what we're asking for here. Listen, if he were to say that it only applied to Tennessee and Virginia student athletes, meaning student athletes either from here or coming here, that would be just fine with me. But I think there would be significant competitive implications from that. We want to protect the rights of our student athletes, and it seems like the fairest way to do that is to have a nationwide injunction here.
A couple more questions.